Hey, what's up y'all money makers? What's up HCMC army? Welcome back to the channel. In this video I'm going to talk about ticker symbol HCMC, Healthier Choices Management Corp, one of our favorite stock on this channel. The stock is trading at 0.0007, so it was between 6 and 7 levels. There is a major update in terms of the lawsuits that we are going to cover in this video. Basically, HCMC responded back to Phillip Morris, and if you remember what we talked about in the past, that was the next step, and the deadline was September 3rd. So we'll talk and look into the review. We'll review the response that is provided by HCMC, what it means, how strong the response is, what is the next step. The catalyst is a big catalyst when the judge is going to rule or give their verdict about what is the motion to dismiss going to conclude as a next step. Now, whether they approve or reject this motion to dismiss has a big impact for HCMC. Remember, what's going on with HCMC is the stock price was went all the way to 0.0035 and then went back to right now what we see at 0.0007. Now here is the chronological order or the timeline or the time frame for this HCMC lawsuit. Before we continue this, I wanted to ask you if you can click on the like button for HCMC Army. This video can reach to more and more people. I'm not a financial advisor. This is not a financial advice. So do your own due diligence and research. I'm not a lawyer or certified professional either. This is my personal opinion review. I do a ton of analysis and I like to share it with you as well, hoping you can make informed financial decisions. So click on the like button, subscribe to my channel if you haven't already, because that is going to get you the news that you need the most right at the time, so you can make informed financial decision. You can take the advantage of the information that you have. So click on the like button, click the subscribe button, turn on the notification bell, and let's watch this video up until end so you can also figure out like what I think. If you have any thoughts or feedback, also write down in the comment section below what do you think is going to be the end result of this particular motion to dismiss that the judge is going to verdict. Now before we do that, I think I wanted to also mention one more thing about the volume. The volume for HCMC stock on Friday was 1.34 billion. That has no impact of this particular response that HCMC filed, because HCMC filed the response after the market closed. The volume of 1.34 billion is below the 65-day average volume of 1.96 billion, close to 2 billion volume. Now, this is an OTC traded stock, so it's not a small volume. We have seen for HCMC the volume up to 40 billion back in the days. So yes, it's not a huge volume, but it's not a small volume either, considering this is an OTC traded stock. There's a ton of information and ton going on with HCMC, as you can see, and they have lots of bells and whistles, including the inter partes infringement against Phillip Morris. They have inter partes review. They have a ton of other information going on with respect to IPR, which is the patent or PTAB petition filed by Phillip Morris as well. Now, particularly for this, the main lawsuit, this is the timeline. We talked about HCMC has amended the complaint. If you want to find out more information, I would ask you to go and check previous videos that I have about the amendment and some of the lawsuit reviews that we did on this channel. Phillip Morris responded on August 20th. That was the second step right here. After Phillip Morris responded, technically HCMC can respond within 14 days. This is an optional response. There is no mandatory response required by the HCMC, but my guess was they were going to do it anyway, and they did it yesterday, late yesterday, after the market closed on September 3rd. So we're going to talk about that particular response that HCMC shared with the court and with everyone else, and I will share the document with you. What is the last step in this whole process? Remember, this is not the lawsuit verdict. This is the judge's final decision on the motion to dismiss that is filed by Phillip Morris. Now, if it gets rejected, that means the case or the lawsuit will get into the discovery phase, onto the next step, and the lawsuit will come onto the floor. That is going to give a lot of leeway for HCMC to negotiate further with Phillip Morris. Phillip Morris has this particular IQOS system, or the device rather, and they have millions of users across the globe. HCMC is suing Phillip Morris for the patent infringement within the IQOS product. The patent is filed by HCMC. The lawsuit was there in November last year. So now the next step is just this decision. But before that, let's talk about what this response is. Let's analyze this. Once again, I'm not a financial advisor, so do your own due diligence. But this is one of the big catalysts as and when the judge rules on this motion to dismiss. Now, so this is on September 3rd, 2021 in the United States District of Georgia, Atlanta Division, HCMC versus Phillip Morris, as you can see right here. And this is a 19-page response sent by HCMC and submitted on time. What they're talking about in the first paragraph, they're talking about the introduction and what the lawsuit is all about and what they are concluding or what they're sharing in this particular response. The second one is that HCMC should be granted to leave to amend because its amendment is not futile. And they have A, B, C, and D for section where they're amendment to complaint is not futile. HCMC's allegation in the amended complaint are consistent with regards to the patent and the evidence of 170. Phillip Morris's futility argument is best premature because it is non-infringement argument requiring the claim construction. And the last part, D, HCMC's allegation in the amended complaint are not contradicted by Phillip Morris's statement to the FDA, which are no longer a part of the record to be proceeding. Now they are responding this one by one. And remember, in the beginning, they had this evidence from FDA and the definition of combustion, so on and so forth. They took it out and put a ton of information about how the combustion occurs. And we'll talk more about a person that they're referring to, a PhD expert. And the last thing is Phillip Morris refuses to address its baseless accusation against HCMC, its principals, and the attorneys. And then there is a conclusion. I won't go in each page because it's not needed and there's a ton of information, but I'll cover the most important things that we should take a look into. I've read the whole document and I'll be sharing only the most important thing that I think I should share with you all. Now, HCMC amended complaint alleges the fact that confirming Phillip Morris accused IQOS device initiate combustion reaction and infringes the 170 patent that HCMC has filed, and HCMC's allegations are substantiated by the declaration of Dr. Michael Diebel, who has conducted the combustion testing on the IQOS system. Now remember, what Phillip Morris mentioned was Dr. Michael Diebel, who is the PhD expert, never tested IQOS product themselves. That's what Phillip Morris mentioned. Now HCMC is clarifying here crystal clear that no, that's not the case. The case is Dr. Michael Diebel, they have conducted the testing themselves. Now this is including the tobacco heat stick, notwithstanding PM's baffling allegation that he did not test IQOS itself. But that's not the case. He did test IQOS themselves. PM Phillip Morris's opposition in HCMC's motion to attempt implored the court to undertake the claim construction at the pleading stage, which is premature and inappropriate. It does so in an effort to entice the court to adopt the narrow definition of combustion that it used in self-serving submission, the FDA, which is extrinsic to the 170 patent and does not really take into account the 170 patent claim specification or the prosecution history, and which is why they are providing additional information, additional evidences, and what the definition of combustion is, and that they're claiming that it is happening partially within the IQOS product. Now what happens is, once again, if we go back to the stock, because if you're the investor, you're mostly interested into where the stock price can go from here. Now if you haven't clicked the like button, by the way, click on the like button, subscribe to my channel. 70% of my users who are watching HCMC video are not subscribers, so I would love to have you as a subscriber. And once again, it doesn't cost you anything. Let's go back and talk about market cap. The market cap is $233 million US dollars, which means if they come into a settlement and if they can, let's say as an example, I'm just throwing out a number because I've heard the numbers pretty clearly on Reddit, in other platforms, on Twitter, so on and so forth. Many experts are talking about, let's say if they come up with a settlement of $1 billion, it's 5 times, close to 4 or 5 times, more or less. the market cap of what the HCMC stock is trading at right now, which means their stockholders are going to be benefited a ton if that happens. Now, which is why it's more important now. Philip Morris is a multi-billion-dollar company. They have spent more than $3 billion into this IQOS product, and they have millions of users using IQOS across the globe. Now, HCMC accused that from the conventional cigarette, their attempt to distinguish IQOS device accused of infringement right here from the conventional cigarette. But it's not the issue here. Philip Morris's self-serving statement suggesting that there is no combustion into the IQOS device need to be taken in context in which they were made, which were not made in the context of 170 patent, which governs here. In my opinion, this is a pretty strong statement, and this is a pretty strong response from HCMC as well. They're confirming two things: that the PhD expert did test IQOS themselves. Second thing is combustion definition needs to be taken into account based on the patent and in context of the patent. So that's what they're talking about. And in the second phase or second paragraph, they're saying HCMC should be granted leave to amend because its amendment is not futile and their amendment to its complaint is not futile. Now, what they're saying right here is, who holds a doctorate degree, which is Dr. Michael Diebel, who holds a doctorate degree in physical chemistry and has done the analysis and concluded that. Now, this is super, super important. I want you to also read and listen to this pretty carefully. That the Dr. Diebel, PhD, concludes that based on the testing and analysis I performed and my review to the technical literature, the IQOS device causes combustion of a heat stick tobacco product when it is operated in accordance with the instruction for use. So there is instruction for use for the product. If you follow the instruction, it does have partial combustion, or at least some sort of combustion. And this is kind of added into the amended complaint. In opposition, Philip Morris's only challenge is to plausibly HCMC's allegation that Dr. Diebel his analysis of IQOS product initiate combustion is that it concedes that he did not test the actual IQOS device. That's what Philip Morris mentioned, but HCMC clarified crystal clear, loud and clear, that that's not the case, which is a pretty strong argument, pretty strong evidence, and pretty strong conclusion by an industry expert and a PhD who is expert in the area. But the PMI's assertion is demonstrated by false. Dr. Diebel made no such concession and did in fact test an IQOS actual device using commercially available IQOS heat stick, which is the sole challenge to the plausibility of the HCMC's infringement claim. And on the top of that, they are talking a ton about what exactly this heat stick combustion and what IQOS device is doing with the carbon dioxide and carbon monoxide when the concentration of oxygen, O2 is oxygen, increases, and that's how the combustion takes place. If you can take a look at my previous videos, you should be able to find that. I don't really want to go too much in deep because this is more of a scientific situation and the combustion. But for the investors, the main thing here is that HCMC has clarified that the industry expert, the PhD, the doctor, has tested this particular device and found that there is a combustion happening. HCMC's allegation, amended complaint are consistent with the original complaint and the intrinsic evidence of the 170 patent that HCMC once again reminds and shares additional details. Their allegation that the IQOS system initiates combustion reaction are consistent with set forth in the original complaint. So what they're trying to say is, we are telling you from the beginning that IQOS has the combustion. We're telling you from the beginning that this particular patent's 170 is being infringed by this combustion, and then there is no particular royalty deals or any sort of licensing deal that IQOS is using to an extent for HCMC's this particular patent, and which is why they're causing the financial burden, and they're asking for they're not asking really anything. They're just telling right now that there is an infringement of the patent. Now, if it goes on the floor on the next steps or the discovery phase, which is when they're going to probably settle this out if that happens. I'm not an expert. I'm just this is purely guesswork, and this is purely just a thought process that I'm coming up with. So do your own due diligence if you haven't already. This is a pretty interesting situation. Now, what they're, in addition, they're also claiming that 170 patent require initiating the combustion reaction, which already is happening, and therefore it was for the reason that the patent officer examiner allowed the claim to issue over the identified prior art references that teach how the electronic cigarettes are intended to mimic the experience of the smoking combustible cigarette, so regular cigarette, without the actual combustion of tobacco. And they're giving more and more and more detail about what they are trying to convey for this particular lawsuit, and which is why it's not futile, and they should have granted the discovery phase or the next phase, and the motion to dismiss that is filed by Philip Morris needs to be rejected. And they're adding more information about the combustion claims, so on and so forth. So that's all IQOS product, how they do it, what is the combustion, how it happens with carbon dioxide when the concentrated oxygen level increases, how carbon monoxide and carbon dioxide and oxygen, all these three elements are involved, particularly when the combustion occurs. So they're talking about a ton of scientific and pretty complex information when it comes to combustion. HCMC's allegation in the amended complaint are not contradicted by Philip Morris's statement to the FDA, which are no longer part of the record in this proceeding. So if you remember, before they had FDA statements, FDA evidence, and basically the combustion definition from the FDA in regards to this particular patent and IQOS product or by IQOS device, they took it back. And now what they are saying is this is no longer the case, and they have furthermore evidence when it comes to this combustion and IQOS product and this patent that they have filed. And lastly, if you scroll through this, and we talked about more a ton of Exhibit J in the original complaint, that it is neither referenced or nor attached to the amended complaint. As a matter of law, HCMC's amended complaint will supersede the original complaint because now there is an amendment. So that becomes the full and final complaint as an amendment, and now original complaint will no longer be a part of HCMC's complaint against this particular for this particular lawsuit against Philip Morris. Philip Morris makes argument that they do not really apply by arguing a lot of other things based on what HCMC responded right here, right now. Now, finally, they're ending this particular response with one more paragraph that says PMI refuses to address baseless accusations against its CMC, its principals, and its attorney. And remember, what they mentioned in the past, HCMC mentioned in the past was basically that they did not really do anything different from their original complaint, but they amended their complaint. And also, what they're mentioning is HCM, their early investor, executive board members are sold literally millions of shares. That was the acquisition during this artificial spike in value of HCMC shares, represented by courts. Factual contentions have evidence to support, and they're also responding to all that. Rather than correct that serious misrepresentation, Philip Morris says instead double down on the sectionable conduct by making the further baseless accusation, including that HCMC has engaged in puzzling security activities during the pendency of this lawsuit, and they're also mentioning that earlier statements as irrelevant to the HCMC's motion. So there is no real point of discussing some of the other things when this lawsuit is about the infringement, because if there is something happen, this needs to be taken care by SEC and some other authorities, but not in this lawsuit. That's what HCMC is saying. They're declining that there is anything happened, but they're also mentioning that's totally a separate story, and this doesn't need to be included or combined right here when there's a patent infringement lawsuit. And what is the conclusion? As the last stage, they're mentioning for the reasons are set forth herein, HCMC's opening brief, HCMC's respectively submits all the motion for leave should be granted, and that is submitted on the 3rd day of September 2021 after the market close. And these are the attorney's information for HCMC and certificate of compliance, so on and so forth. Now, so I wanted to share this information with you. Now, what this also means is this lawsuit has been going on and on and on, starting November 30th, if I'm not wrong, in 2020. Since then, there is a ton going on, and the lawsuit is in an interesting stage at the moment. We have seen ups and downs in the stock price. Patience is the key. This is going to be a hit or a miss. So, and I'm not an expert by any means, so do your own due diligence. I hope you like this video. Click on the like button, click on the subscribe button. I'll see you in the next video. Thanks for watching.